Hello and welcome to ProfDale's Property Video number 34. I'm your host, Dale Whitman. In this video, we're going to cover an introduction to the law of easements. So what is an easement anyway? Well, an easement is a legal right to make a limited use of another person's land for some specific purpose. Easements are very common. They're commonly used for things like streets, roads, and driveways, for electric, water, sewer, and other utility lines, for recreational activities, and for the flowage of watercourses. Those are all typical easements. Now, how's an easement different from an estate? Well, estates give possession, and the word possession means that a person with possession can basically use the property in any way they wish. They can damage it, they could even destroy improvements on it, they could build things on it, they can do whatever they like, as long as, of course, they don't violate the local zoning ordinances or the law of nuisance. Easements, on the other hand, don't give possession, they give only a limited right of use, and the key there is limited. Easements don't give you the right to do anything you want to on someone else's land, but only some limited and specific activity. So why does it matter whether someone has an easement or an estate? Both of them give you the right to go on the land, but it turns out that estates are much more valuable, much more useful, and much more flexible than easements are. Let's look at some of the reasons why this is true. Suppose there is a parcel of land and there are minerals or oil or gas on the land. If you have an estate, you're entitled to those minerals or oil and gas unless they've previously been severed from the surface estate. But with an easement, you don't get any minerals or oil and gas at all. You just get the right to make the limited use of the property that the easement grants to you. Similarly, with air rights. If you have an estate, your air rights are basically unlimited. You can build as high as you want to, subject, of course, to the local zoning ordinance. On the other hand, if you have an easement, your air rights are limited. You can only use the amount of airspace that's necessary to give proper enjoyment to the easement itself. If I gave you an easement for driving trucks, for example, your easement would probably be limited to about 14 or 15 feet in height, because that's all the airspace that the trucks would reasonably need in order to use the driveway. Another difference lies in whether use restrictive scope language in the grant is binding or not. If you have an easement, then use restrictive scope language that says what the easement is for, is highly significant and completely binding. On the other hand, if I gave you an estate and I put in some use restrictive scope language, I said something like, I'm giving you this estate for driving and parking trucks, well, you wouldn't be bound by that at all, and you could use the estate for any other purpose that you wished. So use restrictive scope language is critical to easements, but totally insignificant when it comes to estates. The exclusivity of the holder's rights is another difference between easements and estates. Estates are always exclusive. If you own an estate, you can always exclude other people from it. But easements may or may not be exclusive. Some easements are exclusive and some are not. We have to look at the way the easement was created to find out whether it's exclusive or not. It might be that you have the right to use an easement, but other people could be using it simultaneously. If the property is condemned, that is, if it's taken by a government body in eminent domain, then do you get compensation? Well, estates always get compensation if they're taken by the government. And easement holders are also entitled to compensation if their easements are taken, but estates are generally more valuable than easements, and they're generally entitled to greater compensation. Finally, can you abandon an easement or an estate, and if you did, would that lead to the loss of ownership? Well, here, easements and estates are completely different. Easements can be terminated by abandonment. You can lose an easement if you don't use it, but estates cannot be. If you own an estate, even though you don't use it, you don't possess it, you don't even go anywhere near it, your ownership will continue indefinitely. Now here's an interesting question, one that you'll sometimes see in judicial decisions. They will say, the issue in this case is, did the grantee receive an easement or a fee simple? Well, what's wrong with that question? It's a completely nonsensical question, and yet it gets asked all the time. The reason it's nonsensical is that both easements and estates can be, and usually are, in fee simple. The term fee simple simply implies that the estate or easement will continue indefinitely, and both easements and estates generally do continue indefinitely, and therefore it's perfectly proper to talk about either an easement or an estate as being in fee simple. The real issue in these cases is usually this: is this an easement or is it an estate? So when you're talking about easements, be sure to distinguish them from estates, not from fees simple. Now, of course, an easement doesn't have to be in fee simple. We presume that an easement's in fee simple, just as we do with an estate, if nothing to the contrary is stated. However, if we read the grant, we might find that an easement is intended to last for less than indefinitely. For example, it might be in fee simple defeasible. You'll remember fee simple defeasibles when we talked about estates. Well, easements can be in fee simple defeasible as well. Here's an example. We might say, we grant this land to the railroad for use as a train so long as the track is used at least once each month. I actually once had a case in which that was almost exactly the language used, and it became an easement in fee simple determinable because it would terminate if the use of the track wasn't made at least once a month. An easement might be for someone's life. I could grant you not a life estate, but a life easement. I could grant you an easement for a fixed term for 5 years or 1 month or 20 years. I could grant you an easement, in fact, for any other duration for which an estate can be limited. So all the ways that we can cut short the life of an estate, we can cut short the life of an easement in exactly the same ways. Now, we're going to spend a few minutes at this point discussing the difference between easements and licenses. Both an easement and a license give someone a legal right to be on somebody else's land. But an easement is a real property interest. That is, it's an interest in land. It's a property right. A license, on the other hand, is not a property interest. It's simply permission to be on somebody else's land. And if you think about it, you'll realize that we all have licenses all the time. Almost everyone has some licenses every day. We usually don't even think about the fact that they are licenses. Now, licenses are extremely common, but they're usually brief and rather ephemeral. For example, if we shop at a store, the store puts an open sign on its door or just opens for business and invites us in. And so we have permission to be in the store, and so it's a license. It's the right to be on somebody else's land with their permission. The same is true if we go to the movies. We have a license to sit in the theater. If we go to a sporting event, we have a license to sit in the stands and watch the game. If we eat at a restaurant, we have a license to be there. If we park our car in a parking lot, we probably have a license, although there's a possibility that we also have a bailment of the car, particularly if we turn over the keys to a parking lot attendant. But in any event, we do have a license to be on the lot. If we visit a friend's house or a friend's apartment, we have a license to be there. So you can see that licenses are extremely common, and they don't require any particular formality, just an invitation to come on someone else's land. Now, some licenses are formalized in writing, and some of them last for a longer term. Here are a couple of examples. A corporate skybox at an athletic stadium, where the box is rented to a corporation on a long-term basis, perhaps for a year or a certain athletic season. That's usually a license, but it will be represented with a writing, and it will be obviously for a longer term than just sitting in the stands. Likewise, if you were a farmer and a wind turbine operator wanted to put a turbine on your property, you might give them a license to do so. They'd have the right to come on the land and install the turbine system, and it would have a right to be there for some fixed period of time, perhaps 20 years or so. Now, we can make a little chart that compares easements with licenses, and it's quite instructive to do that. First of all, as we've already said, an easement is an interest in land. It's a real property right. A license, on the other hand, is not an interest in land. It's merely permission to be on someone else's land. You might have a contract right to have a license, and you might not. Some licenses are supported by a contract and some aren't. For example, if you go to a ball game or a movie, you have a contract right to be there to watch the game or the film. On the other hand, if a friend invites you over for dinner, you have a license but no contract at all because there's no consideration and no agreement. So contracts may or may not be present when there's a license. Now, what about the statute of frauds? Well, easements are subject to the statute of frauds, at least easements that are longer than 1 year in duration. That means that to give someone an easement for longer than 1 year, you've got to use a writing. On the other hand, a license is not subject to the statute of frauds. Now, you can use a writing if you want, but a license that's given only orally or only by behavior and conduct is perfectly enforceable as well. What about the remedies that you can get if you have an easement or a license? Well, if you have an easement because you have an interest in land, you can enforce that right by either getting damages if the landowner tries to terminate your easement or by getting an injunction. An injunction's a remedy in specie where the court will actually put you back on the real estate itself. So you have your choice of either damages or an injunction if you have an easement. On the other hand, if you have a license, the only remedy you can get is damages. You can never get an injunction or an in specie remedy. A court won't put you back on the property. Well, the result of that principle is that licenses are always revocable. That is, if you have a license, the landowner can always get you off the property. If you have a license and the landowner revokes it, you have to move. You have to vacate the property and the court won't put you back on. If you had a contract right to be there, you might be able to recover damages for breach of the contract, but the courts will never give you specific performance or an injunction to restore you to occupancy of the land. So what that means is that a license can always be revoked. The landowner might or might not have to pay damages if they revoke your license, but they can always revoke. Well, that covers what we needed to say about licenses, so now back to easements. Easements, in many cases, benefit a specific parcel of land. They go to a piece of land and make it more valuable and useful. We can make a little chart that compares the terminology of easements with the terminology of covenants that we covered earlier. And the chart looks like this. Under covenant law, you remember, we had both the burdened land and the benefited land. Well, in easement law, similarly, we have the burdened land, which we call servient land. That's the land that the easement runs across or over or through. And we also may have dominant land, and that's the land that's benefited by the easement, the land that the easement runs to or toward. Here's a little example of that principle. Owner number 1 has a garage on his land and wants to put a driveway over his neighbor's property on lot number 2. And the owner of lot number 2 is willing to allow that. So the driveway is represented by the purple area labeled easement over lot number 2 running to lot number 1. We can now label which land is servient and which is dominant. The servient land, of course, is the land the easement runs across. That's lot number 2. The dominant land is the land that the easement runs to and benefits, and that's lot number 1. Now, all easements have servient land. That's a fundamental principle because the easement has to be somewhere, and wherever the easement is, that's the servient land. Appurtenant easements, as we call them, also have dominant land. So if there is a piece of land that's being benefited by the easement, we say it's an appurtenant easement. It's appurtenant to the dominant land, almost like it hooks onto the dominant land and becomes almost like a part of it. However, there's another kind of easement, the easement in gross, that doesn't have any dominant land at all. It only has servient land. There are these two basic kinds of easements, appurtenant easements, which have both dominant and servient land, and there is a specific parcel of land that's benefited by that type of easement, and easements in gross, which have only servient land but no dominant land, and the easement benefits its owner, but it doesn't benefit any specific parcel of land. Let's look at some examples of easements in gross where there isn't any dominant land. Cross-country railroad tracks running from one part of the nation to another are usually easements in gross. They don't benefit any specific parcel of land, they benefit the overall operation of the railroad. Likewise, cross-country power lines benefit the electric utility companies, but they don't benefit a specific parcel of real estate. And finally, many utility lines for water, sewer, electrical, and so on are easements in gross that benefit whole neighborhoods or whole areas of a city or town rather than benefiting a specific parcel of land. Now, don't get the idea that every railroad track or power line is an easement in gross. That isn't necessarily true. Take a look at this example. There's a main railroad line, and from that, there's a siding that goes across A's property to go to the loading dock on B's land where B has B's factory. Well, the siding running across A's property is an easement. Is it an easement in gross? After all, it is a railroad track, but in this case, it's a railroad track that benefits a specific parcel of land, namely B's factory. So even though it is a railroad track, it's really an appurtenant easement. We just have to look at the circumstances and determine whether there is a specific piece of real estate that's benefited by a particular easement or not. And that will tell us whether it's an appurtenant easement or an easement in gross. There are some unique legal features of easements in gross that you want to be aware of. The first one is that easements in gross don't transfer automatically with the dominant or benefited land like, as we'll see in a minute, appurtenant easements do. The reason is that with an easement in gross, there isn't any dominant or benefited land, and therefore nothing for the easement to transfer with when a land transfer is made. So the question then becomes, could an owner of an easement in gross transfer the easement by itself? Well, the answer traditionally that the courts have given is that easements in gross can't be transferred at all by the benefited party, their owner, unless they are for a commercial purpose. In other words, a purely personal easement in gross can't be transferred at all, according to the standard doctrine. For example, if I gave you an easement to come and fish in my lake, and you were not doing it for a business purpose, but just because you enjoyed fishing, that would be a non-commercial easement in gross, and you wouldn't be able to transfer it to anyone else. Easements in gross, for the most part, are for a commercial purpose, and so they're perfectly transferable. For example, those long-distance railroad track easements and long-distance power line easements that we talked about before. Certainly the companies that own those can transfer them because they are for a commercial purpose. Now, the restatement of servitudes disagrees with this idea that a non-commercial easement in gross can't be transferred. It says the issue is simply, did the grantor intend for the easement to be transferable or not, and the court should inquire into that intent, but it doesn't depend on whether it's commercial or personal in nature. So the law in that area may be changing. Now let's talk a minute about transferring appurtenant easements, and to do that we'll go back to our little picture of the lots 1 and 2 and the driveway running across lot 2, the servient land, and going to the dominant land, lot 1. So the question is, if the dominant land is transferred, will the easement go with it? Will whoever buys lot 1 also get the right to use the driveway? And the answer is yes, automatically. If anyone buys the dominant land, they get the easement as well. It's almost like the easement was sort of a tail on the dog, and if you buy the dog, you get the tail too. So the easement goes with the dominant land. An appurtenant easement, in fact, simply cannot be transferred separately from its dominant land. So the owner of lot 1 could not give the easement to one person and the dominant land to another. Whoever gets the dominant land has to get the easement as well. Now, what about transferring easements on the servient side of the equation? Let's suppose the owner of the servient land transfers it. Is the new owner bound by the easement? Do they have to recognize it and allow owner number 1 to use the easement? Well, the answer is that whoever buys the servient land is bound by the easement and has to recognize its validity unless they are a bona fide purchaser with no notice of the easement. So it becomes critical when we're selling the servient land to determine whether the person who's buying it has notice of the easement or not. Well, how could a buyer of servient land get notice that there was an easement across the land they're buying? Actually, there are only three ways that that can happen, and we need to know and understand them. The first way is that somebody might tell the buyer about the easement before they purchase the land. The seller might say, the land I'm selling you has an easement running across it, or a neighbor might tell them. They might read about it in the newspaper. So this would be what we'd call actual knowledge, where they, in fact, know about the easement. The second way is that the original grant of the easement, or some document that mentions it, might be recorded in the public records. Now, if the buyer of the property did an actual title search, they'd discover that grant of the easement, and then they'd have actual knowledge. But if they didn't do a title search, they would still be held to the notice that they would have gotten by doing one. We refer to that as constructive notice from the public records. So while it's certainly a very, very good idea for anybody who buys the land to do a title examination first, they're going to be held to the knowledge they'd have gotten from a title examination, whether they did one or not. The third way is that the easement might be observable on the land. You can see it, in other words. We sometimes call this inquiry notice, because if you buy a piece of land and you see a roadway, a driveway, a sidewalk, a power line, or other apparent easement type use on the land, you're supposed to follow it. You're supposed to determine where it goes and then inquire of the owner of the land it goes to as to whether they have an easement. So we call that inquiry notice. Now, once again, if the buyer actually does do that, if they find the person who claims the easement and asks about it, and the owner tells them about it, then they'll have actual knowledge. But they are held to make that inquiry whether they actually do it or not. Now, bear in mind that some easements won't work that way, because some easements are buried underground, and there might not be anything on the surface that tips anyone off that there's an easement down there. Sometimes there is something on the surface, a manhole cover or a pole or a post or a sign, but there might not be anything, and therefore the easement might be unobservable, and there might not be any inquiry notice arising from its existence. Well, those are the three ways that one can get notice of an easement across a piece of land one is buying: actual knowledge, constructive notice from the records, and inquiry notice from what one would see by observing the land. That completes video number 34, our introduction to easements. In our next video, number 35, we'll cover the 4 standard methods of creating easements. If you have questions or comments, email ProfDale01@gmail.com. Thanks for watching.